Good afternoon. Good afternoon, ladies and gentlemen. Welcome to this session on tackling late payments for SMEs. I think that we are very familiar with the expression SMEs are the backbone of the EU economy. We have heard it so many times. And I would like to use and stick to this metaphor and say that for SMEs, money is the blood of SMEs, so if you want to remain into medical terms. And especially in a moment in which we are speaking so much about resiliency, recovery, rescue, the liquidity is extremely important for SMEs on this point. Unfortunately, the issue of payments to SMEs, of timely payments to SMEs, is still a big issue. Pre-COVID, we had assessed that the timeliness of payments, especially in B2B transactions, was not satisfactory. Only less than 40% of payments in commercial transactions were done on time. This left basically an average of 60% of payments that were done later than the contractual agreement. In some sectors like construction or retail, and we will speak more about these two sectors later on, we had estimated that 62% of payments were done systematically later than 30 days. So it means that delays of more than 30 days and above after the contractual deadline. It is a big problem because late payments before COVID was accounting for 1 out of 4 insolvencies and bankruptcies in the EU. With COVID, this situation has escalated and deteriorated. What we have observed, however, is that with the crisis, the public authorities have overall, of course, there are still areas in which more should be done, have overall improved or accelerated their payments to their smaller suppliers in particular to protect them during the lockdown. Probably might have been the effect of infringement procedures that the European Commission had already opened. But overall, we have seen them also in other member states where there are no infringements. So we would like to credit the responsible behavior of public authorities in this particular situation. On the contrary, and this is what was the Commissioner also reminding us this morning, was that in payments between businesses, we have seen an enlarging gap between the payments agreed in the contracts and the actual payment. So an enlargement of the payment gap. We have seen deterioration of payment practices and payment behavior of larger companies compared to small enterprises. Just to give you a few figures, in Spain, companies quoted in the stock market have an overall average payment delay of 191 days towards their suppliers. In the construction sector, the average delay is 271 days. In the retail sector is 259 days. In Italy, 82% of larger companies pay systematically late. So just to give you these figures, this is a real problem because the risk is that the delayed payments will deteriorate the situation for SMEs. Late payments bring more redundancies. They make companies less propense to innovate and invest in innovation. So whether all our discussion on in pushing SMEs towards their green and digital transition will be hampered by the lack of potential and propensity to invest. They simply do not have the money. Companies and small businesses that are paid late, they will slowly progress towards insolvency and bankruptcy. At the moment, late payment in France is the #1 reason of insolvency for SMEs. And more, the big problem is that then the funding, this money that will come through many instruments from the EU, will benefit larger companies and will not trickle down to SMEs. So this is a real problem. In addition, we talk so much about administrative burden. Do you know what is the average time that is spent by SMEs just in chasing their debtors? In the UK, they have estimated that. It is 900,000 per day SMEs dedicate every day to chase their debtors. This is time that they could devote to something more useful, to produce, to grow, to invest, to recruit, to become more digital, to become more green. So what can be done to address this problem? We speak about many solutions: mediation, more administrative, more alternative dispute resolution system, an observatory of late payment, voluntary initiatives, more legislation. So I would like then to pass these heavy messages, I'm sorry, but this is the reality, very heavy messages to digest after the lunch, but we need to speak about them to our distinguished panel of speakers that are with me today. I would like to start with Kareem Karaki from Pwc Luxembourg. Kareem, you are the soul of our European Construction Sector Observatory, so thank you very much for all the help that you have given us until now. So let me briefly introduce you. You are a senior advisor in Pwc Luxembourg with over 6 years of experience working in multilateral and European Union institutions. Kareem work as experience focuses on public policy analysis and evaluation, specializing in EU funding. You have worked as a policy analyst for various international organizations, including the European Investment Bank and the European Centre for Development Policy Management. You have helped public sector actors design and implement economic policies through policy research, market analysis, and financial instrument strategic development. You are the man of the day, Kareem. So the floor is yours, and thank you very much for being here today.
Thank you very much, Antonella. Well, that's a big introduction, and I hope I will live by your words. So I would like to, if that works fine, yeah. So, yes, we were talking about the European Construction Sector Observatory. So it's an initiative that was born in 2015 as part of the Construction 2020 strategy of the Commission. So now it's an initiative that has been running from the past 5-6 years, and the objective is really to help and to contribute to the sustainable and to the competitive development of the construction sector. So to do that, we provide different types of analysis, as you can see on this slide. So we produce what we call the country fact sheet, which is basically an overview of the construction market in each of the EU member states, as well as the UK. From the market, then we move to the policy part, and with the policy fact sheets here, which basically analyze policy measures, instruments, schemes that were implemented in each of the EU member states. And last but not least, then we have those analytical reports and trade papers. So those really focus on an issue that is affecting the construction sector. So as part of these papers, we've looked at issues such as digitalization of the construction sector. We've looked at energy and resource efficiency, all those kind of topics that will hopefully help contribute to the twin transition, like so a digital and a green transition. And of course, we've also looked at the issue of late payments, and this is the main focus of this presentation. So it's an issue that, as Antonella was saying, is affecting the whole of the EU economy, but particularly the construction sector. So I additionally put some numbers here, but I think Antonella already highlighted some key numbers about the impact and the serious impact of late payment in the EU economy. I mean, here you have three numbers on the right part of the slide. 58% of companies accepted longer payment terms than what they feel comfortable with. 6.5 million jobs could have been created would late payment issue been addressed. And 39% of construction SMEs reported problems with late payment on an occasional basis and 17% on a regular basis. And like the last number is also important because it shows you what? That the issue of late payment is particularly prevalent among SMEs. So less for large companies, but it's very relevant for those companies that actually shape 99.9% of construction companies. And the thing is that this figure is from our 2019 report. So as Antonella was saying, with COVID, actually things have gotten worse. So for instance, this figure about the 58% in 2020, with the latest numbers that we have, raised to 73%. And that's basically the case for several indicators that we've looked across in the reports that we've developed. But so in short, late payments issue is becoming more and more prominent, and also the industry, but also policymakers are thinking and trying to do things in order to tackle this issue. But to do that, what's very important is at least you need two things. The first one is a good understanding of the causes of late payment. So you need to understand why we have this issue. I mean, I won't be too detailed because we have little time, but among those issues that and the causes of late payment in the construction sector, I will just name the fact that there's a lot of unfounded disputes. The verification period is often used as a way to delay payments. There's also a strong power imbalance between actors in the construction value chains as well, which also help explain why we have so much late payment affected SMEs particularly, and so on. So just to make you understand that if you want to tackle properly this issue, then you need to have a good look at their causes, because this is a very complex issue. And besides understanding then the causes of late payment, then what you need to have ideally is a good look at the data behind late payment. So what kind of data do we have in order to develop policies that are going to be evidence-based, like fact-based? And that's the thing, one of the main observations from this report is the fact that today there is a lack of data regarding late payment in Europe. But more than that, as you can see here, we're talking about harmonized data. What we mean is that the data today that we have on long-term late payments is very much scattered between different institutions, whether public or private, that are gathering all together some information about late payment. But there is not one methodology to assess late payment. There is, like, each actor has their own way to define and to assess late payments. So it's quite an issue in a way, but it didn't prevent some policymakers to actually take some initiatives in order to address this issue. So you can see that this issue is taken very seriously, both by the industry and by public sector actors. So there on the slides, I just wanted to basically show you a couple of preventive and corrective measures to address late payments, and that are divided into two categories. So the hard regulations and the soft regulations. So the hard regulations essentially refers to binding mandatory regulations that companies and public authorities also have to comply with. Otherwise, they can also be sanctioned. While soft regulation is more some kind of, as you can see on the slide, codes of good practices, code of good conduct, awareness raising campaigns, and these kind of things. So there is a large range of options that the private sector and the public sector can use in order to tackle late payment. But what we've seen is basically that most of the actors tend to focus on the preventive parts of late payment. So they want to prevent late payment from happening, and that's where we see most of the initiatives going. And they combine both hard and soft regulations, because basically it's such a complex issue that you cannot rely just on one set of instruments. You have to actually find different tools, different approaches that together will help address the issue of late payment. And this is why also from a policymaker's perspective, it's so complex to address it. So here, and I'll be very short because time is running, but we have also looked at, basically what works, what doesn't work in practice as well from all those policies that we've analyzed. And I will not read the slide because it's a lot of text, so I just focus on some parts of it. In terms of the preventive measures and the soft preventive measures especially, so we have those code of good conducts, those code of good practices that are often led by the industry, sometimes also together with governments. And what we've seen is basically that if you want this to work, if you want this to have an impact on how companies are paying, then those initiatives should be ideally accompanied by a monitoring mechanism, but also a possible reward/sanction mechanism when they don't respect, or when they do respect, the good payment practices that they advocate for by being part of these initiatives. In terms of the hard regulation, and I think I'll stop here as my last point, but what's interesting is that what we notice is that stricter or shorter payment terms regulations have not yet had much impact. So it means that you can, reducing the payment terms from 30 days to 15 or from 60 to 45 will not have much impact on the ground, because there's a difference between the theory and the practice, as actors are using different ways to deal with late payment. Instead, what we recommend as part of the report is actually to focus on rather practical solutions, such as the electronic invoicing system, the project bank accounts, and payment performance reporting, which seem more promising avenues in order to improve companies, but also public authorities' payment behavior. So I think that's the kind of things that I wanted to share with you in order to set further the scene and give you more explanation about late payment, at least in the construction sector. And I would like to thank you then for your attention, and I welcome any questions you may have. Thank you.
Thank you very much, Kareem. This was a truly inspiring presentation, very complete, very complex. Indeed, it's a very complex issue that I agree with you. There is no one-size-fits-all solution. So, but indeed, there are different avenues that we can pursue, and it was very good that you provided an overview about this. Our next speaker is Spiros Mathiudakis from the European Builders Confederation. We will still remain in the construction sector because it's a sector. Sorry, that's. I'm told that there's a change in the sequence, so we will have a video from these Slovenian authorities. I have here the presentation from Mrs. Nina Stražizar. I'm sorry about the pronunciation, Nina. Nina is the head of Insurance and Capital Market Division at the Ministry of Finance of Slovenia since January this year. This division is responsible for preparing a system-wide solution and regulation in its field of work. It covers EU dossiers such as Solvency II and Capital Market Union, digital finance package, and sustainable finance. Nina is a statistician by training and has an experienced national account expert in macroeconomic statistics at the Statistical Office of the Republic of Slovenia. So we will now have the views from the public authorities, and we have a video from Nina. Thank you very much.
Dear speakers and distinguished guests, it is a great pleasure for me to participate in this event, and I would like to thank you for the opportunity to present the Slovenian case on the issue of late payments. I will in fact, briefly tackle the legal framework, policy developments, monitoring, and combating late payments in Slovenia. So let me start with a brief overview of the current situation regarding payment discipline in Slovenia. As a result of corona crisis, the creditworthiness of many companies in Slovenia has deteriorated. However, current analysis for Slovenia do not show a significant decline in payment discipline. This is naturally attributed to the effect of state aid. Therefore, after the withdrawal of state measures due to COVID-19, companies will have to rely on their own liquidity. And it is expected that companies with greater financial strength, which have been able to reorganize and adopt to new standards and market requirements, will of course be more successful in their further business path. In Slovenia, the Late Payment Directive was transposed into the Act on Prevention of Late Payments in 2012 by the Ministry of Finance. In addition to the requirements of the EU directive, National Act regulates multilateral netting, a way to terminate mutual financial obligations directly and indirectly. And it is carried out once a month by the Agency of the Republic of Slovenia for Public Legal Records and Related Services, IPES. More precisely, IPES performs a multilateral set of liabilities and receivables between business entities, usually once a month. Both legal entities and individual entrepreneurs can participate in a multilateral set of procedure. And this service provided by IPES provides a fast, simple, efficient, and cost-effective way to settle obligations or recover receivables. In addition, IPES also manage the Slovenian Business Register as a central database for all business entities in the Republic of Slovenia that carry out a profit or non-profit business activities. Under the provisions, the Act on Prevention of Late Payments also empowers interest associations of economic entities to adopt a code of conduct for members to ensure better payment discipline, and has introduced the enforcement order into the Slovenian legal system. An enforcement order is a document which contains a settlement by the debtor, obligating him to pay a certain amount of money. It represents the debtor irrevocable consent, which the debtor gives to his banks to pay the creditor the amount specified on the enforcement order from the funds in his bank accounts. And it is intended to make the enforcement claims simpler and more efficient. And this enforcement order can only be issued by public authorities and economic operators, but not by natural persons. In addition, the legal framework in the Slovenian Public Procurement Act also creates the basis for combating so-called unfair payment practice, and aims also to eliminate unfair business practices, thereby protecting small and medium-sized enterprise SMEs in particular. In addition to the Slovenian legal framework, which is the basis for combating late payments, there are also several voluntary initiatives in Slovenia related to good payment practices. Among others, declaration to promote higher payment discipline was proposed and elaborated by the Slovenian Chamber of Commerce. And this declaration was already drafted in 2010 with the aim of improving payment discipline in our country. In Slovenia, there are several other programs and initiatives aimed at helping business to make greater use of factoring, credit facilities, and other forms of financing. For example, IPES provides users of the web portal with free insights into public data on bills, protests for non-payment via the application. So by entering search terms, users obtain information on the date of the protest, for example, and then the amount of the debtor's obligations, possible partial repayments of bill obligations, and so on. And I need to mention also that the register of bills of exchange protested non-payment, RPM, which is a single public register in which notaries, in accordance with the law on bills of exchange, enter data on bills of exchange protest for non-payment if the bills were issued by economic entities. RPM makes it possible to verify whether a business entity as a debtor meets its obligations under issued bills of exchange, which increases the security of the business environment in Slovenia. Moreover, the volume of factoring in Slovenia is increasing by more than 20% per year. The rapid growth of the industry is expected to continue as the volume of factoring is just under 4% of annual GDP, which is significantly less than in factory developed countries where this share is over 10%. I would also like to stress that the Slovenian government supports the growth and development of SMEs, as they are the backbone of our economy, employing almost 70% of people and generating 65% of the revenue of all businesses. And this support is provided mainly through financial initiatives from the Ministry of Economic Development and Technology and institutions, as well as through institutions specializing in financial companies, for example, the Slovenian Enterprise Fund and Slovene Export and Development Bank. In conclusion, our legislative framework, together with public and private initiatives, has tackled the problem of late payments in Slovenia and, of course, will continue this work in the future. Finally, I would also like to emphasize that Slovenia welcomes the efforts of the Commission with the EU Observatory on payment behavior to track developments across the member states. Thank you.
It was a very interesting video from my point of view, because it shows the role of public authorities in leading good payment discipline. The Late Payment Directive places a special responsibility on public authorities to be leaders of prompt payment, not only to pay on time, but also to build a business environment conducive to prompt payment. So it was very inspiring. What we were discussing before, there is no one size fits all. So she mentioned synergies with public procurement, the need for SMEs to access information about their prospective partners with whom I'm entering into contract. Is this partner a good payer? Can I rely on it? What kind of measures should I put in my contract to protect myself from the possibility of late payment, digitalization, factoring, invoicing, so a plethora of solutions. I also wanted to mention that Slovenia, at the onset of the crisis in 2020, adopted a temporary legislation that accelerated payments to small suppliers in 8 days, which is quite remarkable. So there is it's a good message about that. But let's move on with our speakers. We go back to the construction sector again, because this is a sector that we really like it a lot because of the exceptional presence of SMEs in its supply chain. Also because it's the sector for which we have this pilot on the observatory. And who better than Spiros Mathiodakis? So now it's time for Spiros. to intervene. Spiros is a policy officer in the European Builder Confederation. He's a European, the EBC is a European professional organization representing national construction employer associations at micro, small, and medium size. His work focuses on sustainable construction policy in the EU, including energy, circularity, and environmental policy. So without further ado, Spiros, who is joining us from Brussels, the floor is yours. I suppose you're in Brussels, yes? Or Cyprus?
Brussels.
Okay.
In Brussels.
The floor is
Thank you
yours.
very much.
Thank you.
Thank you very much, Antonella. It has indeed been a very interesting intervention that you made at the beginning, and also Kareem after you. So you gave some very interesting facts about the situation on late payment. Just a couple of things about EBC. Okay, you should have the slide. So EBC, as you said, is a European organization representing employers of the construction sector for SMEs. It has been established in 1990. We are based in Brussels. And we exclusively represent the interests of European construction crafts, micro, small, and medium-sized enterprises. This makes up more than 99% of construction companies, actually. It is therefore the vast majority of construction companies that are SMEs in the EU. And as you can see, the share of construction is considerable for the European economy. It is about 9% of the European GDP, with 3.4 million businesses and 18 million workers in the construction sector. Now, on the issue of the day, it was already mentioned in the presentation by Pwc that there can be different measures that can be used to address the issues. However, it's important to have a look at the issues first. And our reading of the situation, I'm going to try to be brief, but it is important to say which are the main issues. So for us, a major problem is the fact that the controversial and ambiguous concept of grossly unfair is present in the directive that governs the situation of late payment dating back to 2011. The payment of invoices beyond 60 days without a limit can be allowed if one of the parts considers that there's otherwise it would be grossly unfair for the transaction. And this is about B2B relations, and when it comes to public administration to business relations, the 30-day period is often extended to the 60-day limit, and also beyond, using other methods. So the late payment directive allows for the procedure of acceptance or verification to take a maximum of 30 calendar days from the date of the receipt of the goods or services, unless otherwise stated in the contract, and provided it is not grossly unfair. However, the approval period in B2B and public administration to business contracts is often used as a tool to purposefully delay the payment obligations, either by using the grossly unfair provision as already stated, either by requesting enterprises to delay the submission of invoices although the verification has already been successfully conducted, or by requiring enterprises to delay the issue of the document which certifies the end of the verification of the works. So you can see that there are some tricks that can be used and that are very often used, unfortunately. There's also the well-known pay if paid clause that can be included in B2B relations, which require payments from the customer as a condition precedent to the contractor's duty to pay a subcontractor or supplier. Then we have the pay when paid clauses in B2B relation, which govern the timing of the contractor's payment obligations to the subcontractor, usually by indicating that the subcontractor will be paid within some fixed time period after the contractor itself is paid. Then we have the rejection of payments by public administrations if there is any difference between the amount requested by the enterprise and the amount accepted by the public administration, which obliges enterprises to issue a new invoice with a new payment deadline, legally prolonging the overall payment time. And finally, there is often a request for discounts for prompt payment in B2B relations, which are arbitrary discounts for paying before the payment deadline or even just on time. And I happen to know that this is not just the case in the construction sector, but it's very often the case also in the retail sector. That said, in EBC we have certain policy recommendations. So it was interesting to hear the different points of view on whether software measures or hardware measures of law could be effective. In our point of view, unfortunately, many soft law initiatives are not very effective. We saw, for instance, that the measures for arbitration are not picked up by the private sector, they're not used, and this is due to the fact that there is very often a big gap between how strong one player is in this transaction. It is very difficult to take your customers to arbitration or to court. So we see that soft measures very often do not work. And given the fact that this is a major problem, EBC has suggested a few actions. We also have a dedicated policy paper, which you can find on our website. So we suggest a couple of measures at the European level, specifically defining an obligatory maximum period of payment not exceeding 30 calendar days for all commercial transactions. We suggest making the application of interest a legal obligation from the first day of late payment and apply the statutory interest rate for late payment in business-to-business transactions. And we believe there is a need to define an obligatory maximum duration of 30 calendar days to ascertain the conformity of services or goods starting from the day of the finished service or received goods. So the prolongation of the 30 days, either for B2B or for public administration to business relations, should not be an option anymore, given the situation and the fact that 10 years after the introduction of the initial directive, we do not see significant improvement as we would have wished. Then it was interesting to hear the points from the Slovenian presidency, because there are also measures that can be taken at national level. So, for instance, if the main contractor exceeds the maximum payment period of 30 calendar days, there could be measures to ensure that subcontractors can directly claim payment from the contracting authority as a form of, as foreseen in the Public Procurement Directive. And we know that in many member states this is not happening at the moment. There could be an improved enforcement of legislation on late payments, including proportionate administrative sanctions in case of violation. We suggest that enterprises should be allowed to hold back on tax payments if services and goods delivered until payment of those is received, for services and goods delivered until payment is received. And we suggest that governments set up and promote mediation and measures such as mediation at the national and local level, but always keeping in mind that mediation has its limits in terms of what it can deliver. And lastly, we suggest that an increased support for credit management and education and training is introduced, because we often see that people do not know the tools that are available. Even in the cases where some tools are available, we see that many people in the market do not know their rights, basically. So this can also be something that can help. So these were very briefly some ideas from my side, and I'll be happy to take any questions going forward. Thank you very much, and looking forward to hear the next interventions. Thank you.
Thank you very much, Spiros. This was a very, very interesting presentation as well. A lot of food for thought. Please, Kareem, come. It's nice. Also, I found it very interesting because it shed, from my point of view, light on the unfair practices. Which is something for which, unfortunately, the directive is not sufficiently equipped. The directive makes a lot of reference to the concept of grossly unfair and unfair, but unfortunately there is no definition of what is grossly unfair and unfair, and so this makes it extremely difficult, its enforcement and implementation. And you mentioned also something very interesting about the automatic payment of interest. This is indeed a big problem, because the directive contains provisions on payment of interest and compensations, the famous €40 compensation, but our statistics tell us that more than 70% of businesses never claim interest and compensations when they are paid late, because they don't want to ruin the relation with their commercial partner, let alone they would take their late payer to court. So one of the main objectives of the directive, which is to make late payment a reprimand, that the practice of late payment is not working. So thank you very much for giving us this insight. Now let's move quickly to our last speaker, also joining probably from Brussels or Denmark. Lasse, you're in Brussels.
Brussels, yeah.
Brussels, excellent. Lasse is the Senior Director of EU and International Affairs, which is the Danish Chamber of Commerce. I will not use the Danish translation. Lasse is also the Senior Director is the Chairman, of the Committee for Internal Market, Consumer and Digital Affairs of Eurocommerce. It's also a member of the Commission's Fit for Future platform and a similar entity in Denmark, as well as a guest lecturer at the Copenhagen Business School. He has worked in the European politics in roles as the Danish Chamber of Commerce, Danish Public Administration, and the European Commission for over 15 years. Lasse, we are looking forward to your intervention, and thank you very much for being with us today.
Thank you very much for inviting me. I'm very much looking forward, and thank you to the previous speakers for their interventions as well. I guess in this, let me just see if I can get these to work. There we go. Right. So I guess I will provide a little bit of a devil's advocate argument here, because we see it slightly differently. But just to start out on the background, so the retail and wholesale sector represents 5.5 million businesses, and we handle millions of transactions on a daily basis. Most of them are between SMEs. The average payment terms in our sector is well within the 60 days. And in fact, I think the last time the actual studies were done, there were 40 days on average. That being said, of course, there are some late payments that are still in the system. This is clear. And just to be clear also, to not conflate two different issues. I mean, the two types of late payments, there's within the contract, and then there's a discussion about whether how the contracts should be done and whether that is grossly unfair. And then there is beyond contract. We, of course, have no sympathy for paying beyond the contract. Payments that are agreed should be paid at the time that they are agreed, without exemption. So, but the discussion about whether things can be agreed within the contract, we see slightly differently. So, as Kareem also mentioned previously, perhaps important to just circle the issues. I mean, there are clearly national business cultures. The problems of late payments vary a lot between the different member states. And some, and you can see especially those who have widespread use of e-invoicing, have much less of a problem in this area than others. The economic conditions now, of course, exacerbated by the pandemic, makes things difficult. The asymmetry in the supply chain is a reoccurring issue, and basically not one that you can solve by using stricter payment terms, because they will just move things to a different part of the contractual agreements. And then the question of late payments for public administrations, of course, we have no horse in the game. We want public administrations to pay promptly. As far as we have understood, the Commission evaluation so far has not concluded there was a need for legislative changes. There have been evaluations previously, and I understand that the Commission now perhaps have taken a slightly more forward look on this, but so far, as far as we can tell, there has been no calls for legislative changes in the actual evaluations done. Now, in terms of the proposed solutions, and I should say also that this is currently being debated in the Fit for the Future platform, where I also sit, where an opinion will come out shortly. The regulation of payment terms, I mean, the obvious choice is to do 30 days for everything. We think that that will be ineffective. Freedom of contract, so the idea that the companies can, between themselves, agree what is most beneficial to them, we think is helpful. It shouldn't be a public job to demand when things are paid if two companies of their own free will and volition can agree amongst themselves how this should be done. Unless, of course, it's grossly unfair, which is included in the Late Payment Directive as is. Then there's a discussion of a one-size-fits-all versus the sector-specific regulation. In the retail sector, we have a number of different products, like millions of different products. And they range from slow-moving products to very fast-moving products. And for the slow-moving products, for example, in the entirety of the fashion sector and so on, it is very common that payments are prolongated. You get the spring collection in, and then you basically pay for it when you've sold it to your customers and so on. So outlawing such things by doing a one-size-fits-all appears to be in no one's interest, and certainly not in SMEs' interest either, who are often the people who get these things in on consignments. Then there's a question of trying to address the asymmetry in the supply chain. I mean, the obvious way to go about that would be competition law, because it would basically be abuse of dominant position if you do these things. Trying to solve it with addressing one part of the contractual agreements, but not the others, would, it stands to reason, merely move the interest in the contract towards other things. So it would be price, most logically. Basically ending up with the SME being paid less for what it is that they wanted, and I'm assuming that is not in the interest of anyone to end up in that place. Transparency, we're fans. I mean, as long as it's done in a way that's not too heavy-handed and isn't too burdensome, and actually serves the purpose, we are open to having transparency in this area. People should pay their bills on time, and if they don't, it is fair that it is open for people to see. We believe in sharing the good practice from the member states where these things actually function, or people who have good experiences, Any sort of education, of course, so that people know the rules and are able to exercise the rights that they do in fact have. And then we see quite a bit of positive opportunities in e-invoicing, where the invoicings are basically set up previously, so that there is no question of doing it at a different time. So in conclusion, from my side, regular and elective payments we do not believe will be effective in terms of serving the interest of those involved. SMEs are also debtors. They buy things from other companies as well, and making a very strict regime for when payments can be followed would not be in their interests either. We are very big fans of trying to respect the particularities of the sectors included, so that it fits the sector that it is trying to address. I am not an expert in the construction sector, so I would not be able to say whether that what would be appropriate in that area. But for the retail sector, there is a lot of different things going on, and to do one size fits all would not be beneficial. The asymmetry in the supply chain will not be addressed by these things. It will still be there, and the pressures will be applied in other parts of the contracts if such things are indeed done. Transparency, as I said, if done